Brief introduction for Chris. Chris has been licensed to practice before the U.S. Supreme Court and all the Ninth Circuit federal district courts, and has done a lot of work in California for 40 years. He's probably the most experienced employment attorney in California. He's addressed the Assembly Committee that was creating AB5 on behalf of some trucking companies. He was called in to address the Senate Committee regarding independent contractor status. He's represented businesses against the California Employment Development Department in over 300 independent contractor state status cases. And also, how many people in the audience know what the term 20 questions for a consultant means? Many of you do. So this has kind of become more passé now, but Chris was involved with putting those questions together. So he's been around the block. Take it away, Chris.
Okay, thank you.
Now what I've done, by the way, is I have summarized. This is kind of funny. I've summarized your slides on your handout on these sheets. And by the way, pretty much everybody here should have gotten a PDF in the email today with the backup for this. So a lot of that info in that PDF is covered here, but there's some details in that PDF that are not. So go ahead.
Did that include the citations that you sent out?
Well, let's see. No, there's the three detailed sheets for A, B, and C.
The slides.
Those ones, those are very detailed. So I did not include those in the slides.
Yeah, I see a lot of pens and paper. I brought, I don't know, 15 or 20. I'm going to be looking at something that has citations, and you guys probably like that part, but I don't really have time to go through all of that. What I want to do is to stay away from the vagueness if possible. I want to give you something that you can walk away with and say, okay, that sounds like something I might want to do, okay? And I only say might because it's not 100% clear, especially at this time, because the vagueness, the ambiguity, the contradictions will all be filtered through the courts, and maybe 10 or 15 years from now we'll have an idea what that means. But you know, right now we can only make our best guess. First of all, you need to, and probably you've all looked at AB5, you need to understand where these different sections belong, okay? You've got three companies involved. You State of California divisions. You got the Labor Commissioner, okay? That's one category, and I am going to give you this citation just so you know. In AB5, that starts out with the Labor Code section 2750.3, which it's under section 2. Okay, so that's in section 2. And that is effective January 1, this coming January 1. Workers' comp, which used to be pretty similar.
Let me just grab my.
Sure. Workers' comp, which used to also be under the Borrello case, which is identical to the EDD, except that on top of that, the Borrello case said, well, yeah, that's fine about the EDD part, but you've got statutes you've got to consider too. So it's a two-pronged test for Borrello for workers' comp. It's only one for EDD. Workers' comp is section 3 in AB5. But you only need to read the first code section, and you only really need to read the last part, which says that it's going to go back under to the Labor Commissioner part. But it is effective July 1st. So as of July 1st, the Labor and Workers' Comp will be following basically the same law. There are distinctions, but the general ABC test and some of the subcategories and exemptions will be the same. Then the EDD, the primary test there is section 5 in AB5. And that is the, what they did is they messed with Unemployment Insurance Code section 621B. 621B was the old section that said the common law applies for independent contractor employee status. And that, of course, brought all the cases in. So there are hundreds and hundreds, literally hundreds of cases that started in 1946, the first Supreme Court case. Hundreds of cases that define independent contractor under the old law, which now is changed, except in some places. So Chris, but those are the three divisions that you want to look at with those things in mind.
So there's going to be a lot of confusion with all this stuff, with all the different sections.
Right.
So what I tried to do is simplify it with these slides
Right.
Then I think after we go through these slides, you can get down deeper into those other citations
Okay.
and all. But I think this covers the meat of it.
Yeah, I'm going to stop with the citations now.
Okay.
So I was only going to do it on the first part. Okay, I do want to start with something that may help you mentally. I've already heard the word hire a dozen times tonight, maybe 20 times. You hire employees and create a one-on-one relationship. One is dominant, one is obedient. It's a person-to-person employment relationship. If an EDD auditor hears you use the word hire, they know that you know about that relationship and you're dead in the water. Independent contractors have a principal and a contractor, and in between there is a contract. That contract spells out the relationship between these two individuals. So they do not go head to head, they have a contract in between. Conceptual, and you've got to use that. You just got to do it. Okay, now, I want to get to the good news first. For the Labor Commissioner and Workers' Comp, remember they're going to be under the same ones, there is an exception to application of the ABC test. And that is going to indicate that, and one of those is an engineer, okay? So you're exempt from it. You're exempt from the ABC test, except you still have to prove yourself under the Borello case, which you've probably already done. So that shouldn't be a problem. And again, then workers' comp will fall into that same category in July 1st. And to satisfy that, you do need to have an active California license. Okay, so if you don't have an active California license, then that exemption doesn't apply. So then for the EDD test, there's an interesting wording that says that this shall remain in effect, which is an exception, and the exception is a rebuttable presumption, which rebuttable presumption means that you are presumed to be an independent contractor if you have at least a 4-year education, or college education, and you're active in that particular activity. Okay, an engineer is one in that category. The part this is one of the ambiguities, and I need to tell you this. It says the exemption shall remain in effect. Well, the exemption is a code section that says that what I just said, it's a rebuttable presumption, which changes the burden of proof from the government who says you're wrong. Now all of a sudden the government's wrong. It's a big deal, okay? It's a big deal. All of a sudden you're the guy that says, I'm right, I'm an independent contractor. If it remains in effect, then the Borello case,
Oh, hold on. Let's get these.
in any tax case, if any tax government comes to you and says you owe $10 or $100 million, you're wrong, and you got to prove they're right, or you're right and they're wrong. Okay, but that switches with this exemption I'm talking about. Okay, so it is a big deal. So, but now it says remains in effect. If it really remains in effect, then the Borello case would be the one that you have to work with for the exemption. But the Borello case is no longer there because they changed the law to the ABC test. So maybe it's the ABC test, maybe it's the Borello case. Okay, I could argue both sides of that. I'm not going to do it tonight. Okay, so now let's go to the ABC test. You probably all read this, so I'm not going to read it to you. But the first one, the important part here is in performance of the work and in fact. Okay, what you need to do is have a written contract. At law, a verbal contract's enforceable. Here, you want a written contract. But then you also need the facts of the relationship that you have with your client to support the lack of control. Okay, that's generally it. I'll get down to more details on that in a moment. The good thing about the A test is you probably all meet it anyway, because the A test is just a narrowing of the Borello case. Okay, it's not as broad. There aren't as many factors in that. So that's probably one you don't have to worry about, except for the fact that you need the written contract and you need the facts to support your position.
If I could just add something, I have personally included verbiage. Can you hear me okay?
Yes.
Yeah, I've personally included verbiage in my invoices for about 25 years saying that I perform this work independently of the control of whoever's hiring me. And so I put that verbiage in my contracts and in my invoices for years. So this is nothing new about this. If you don't know about this, you should be aware of this. Make sure that your independence and your ability to control what you do is always known to both you and who's ever hiring you.
Sometimes what I do is I take like the 20 sections or this, I put it right in my contract that we're agreeing to all of these things. So that way, if it ever gets questioned, it says, well, it says so in the contract that, you know, both like the person contracting me and me are agreeing to this. Is that like not a bad idea?
No, listen,
Yeah.
the better you can make the contract to support independent contractors, the better you are off, including control. Now, but the control issues that you want in your contract are far beyond just the control of the services, as it says here, performance of the work. See, that's the narrowing of it. Borello is much broader than that, as you probably are aware, and it takes into consideration the factors that surround the preparation for the work, how your education, how skilled you are, is it a short-term project or is it a continuous relationship, all kinds of different things. All those should be covered in the contract. Now, okay, the law and EDD auditors, which is really your concern, EDD is more in the labor than workers' comp. Anyway, your concern should be in regard to making sure that the B and C sections are covered, because A's going to take care of itself, at least in the contract, because you're going to put it in there, and then you just follow up with the relationship. The B portion is more difficult, and this brings us to the interpretation industry. And for the real question here is what is outside the usual course of the hiring entity's business? Okay, what is outside? Interpreting industry. It's very interesting. Everybody in the interpreting industry has always said, we're in the interpreting industry. But they're not. You've got schools, courts, medical institutions that, due to ADA, bring students in, patients in, whatever. And if they bring students and patients in, under ADA, they've got to get them an interpreter. Okay, so they've got to be equal as far as the services they can receive. In doing that, then the school would contact the interpreting agency and say, I need French, whatever it is, deaf person, whatever it is. Then the interpreting company has contracts with all these different interpreters with all these different skills. And so they send out what they call a blast and say, you know, do you want to time the details, and do you want this job? Yes, I want the job. Fine. So that's the interpreting service, is what that skilled individual does. The person in the middle, the company in the middle, is only a matchmaker. I used to say a referral company. This law bastardized referral, so I can't use that word anymore. There are other words that I can change. But the result is that there's a big difference between somebody who puts A and C together and just sits in the middle and points fingers and says, okay, I get from the school, I get these are all the details. I don't create the details. Here are all the details. And here are all the details. This is what they want. Do you want to provide those? So you jump over the middleman, you jump over the matchmaker, totally different business. Before this law, in the last 3 years, I've had 7 interpreter company cases and won all 7 of them, using that concept for lack of control under Borello. So it works. Okay. Does that, any questions on, I think that's a good analysis. Yeah, I think you were
Where's our
first.
microphone for up here?
So just to clarify on the lack of control,
Mhm,
I mean, my clients say, this is what we want you to do,
mhm.
but they don't say, this is when we want you to work,
Right.
and this is what methods we want you to use, and all of that.
Right.
So does the lack of control exclude the fact that, I mean, the objectives of the contract are set by the client?
No, that's a great question. I'm glad you asked it, because that is the basis of the Borello control test. Who has the right to control the manner and means of achieving the end result? Okay? It's the means of the end result that is the control issue. You can control the result. You're contracting. They want you to paint the sign, you know, and make it red. Bingo. That's the end result. That's the end result of the contract. No problem. And that remains the same.
About the point B, the performs work outside the usual course of hiring entities business. Say, if you're contracting for a big company like Google or Juniper or whatever, now they have hired you because they,
No, I contracted with you.
sorry.
Yeah, I know. You didn't want to be their employee.
They contracted you because either they didn't have the right skills or they didn't have the capacity.
Right.
But it's very difficult to prove that a company like, say, Google or Juniper or SanDisk, they are not in business that they have contracted you for. Because there will be some other groups in that company that may be doing similar work at a higher level of complexity or lower level of complexity, but they're still doing the work.
You're in an area which is very tender to my heart. The reason is, I represent still do small businesses. And when I started my independent contractor stuff, 2 of the clients I had were brokers in Silicon Valley who were then placing temporary personnel as software engineers. And the EDD was coming in and winning those cases because what they were doing is saying, well, we've got these, 75 or 100, whatever it is, software engineers coming in and sitting down, and they needed 6 weeks of training in order to start the project. It's semantics. They weren't being trained. They already knew how to earn a living with their skills. They were being oriented into how to be compatible with the rest of the people, as well as the mainframes in those days and all the different things. It was an orientation. Okay, so it's that kind of distinction that you need to make in what you're talking about. And you can do it.
Good question?
Here. So to follow up on that, what about software engineering, which is one of those disciplines that affects me, that it's not very clear what is to control or not to control? I mean, there are many ways. I'm curious about the independent from control of the company. So if you're hired to do some sort of software project, how is that you are free?
Well, you're getting down to, I'll forget you using the word hired for a moment, but
Yes.
you're getting down,
You're contractors.
you're getting down to what this gentleman brought up a moment ago, and that is, it's the end result. I mean, if he's saying you were hired, he should be kicked for that. But if you were contracted to, meet this milestone by 10 o'clock next Wednesday, and it's now noon, and you failed, that's an end result.
Only that even if it is not a big company, I do chip design.
Okay.
And there are many chip design companies that hire consultants to do specific things because of the specific experiences those people have. Now
That's the big, yeah, that's the big.
If I can try to answer that.
Well, I answered it with the interpretation company. So that's, I mean, it's the same thing. With B,
Here,
let me,
let me jump into that.
well, I've got it, this is, go ahead.
If I'm talking with you, Chris, the key thing is, define something to enough particularity, like a really fine-grained definition of what you're going to do. And even if it's working on a particular project, even if it's similar to what other people in the company are doing, nobody else is working on that particular project under that contract except you. I mean, that might seem like a really pushing the envelope there, but it's, in talking to Chris, that's enough of a distinction.
Yeah, let me get into I wasn't going to do this, but I am here. On that issue, the Supreme Court in Dynamex, by the way, the Supreme Court in Dynamex was very narrow. I mean, all it related to was wage and hour regulation. It was a very narrow, tiny little segment. But anyway, got blown out of anyway, it's atomic bomb now. But anyway, what the Dynamex case does is there's 10 pages out of that 85-page case, I guess it's 9 pages, that actually cover and explain what the Supreme Court was thinking. And because of outside the usual course of business, I want to show you the comparison that the Supreme Court makes. In the outside of the normal course of business, they use the comparisons, very simple, as contracting. They actually use the word hire. And that's because they want employment. Anyway, yeah, so they use the word hire, plumbers or electricians. Now, you know, if you're a retail store or a law firm or whatever, obviously that's outside. It's very simple, that's black and white. Most of this is very, very gray. So, there's a Connecticut case, and Connecticut came up earlier, there's a Connecticut case that they cite that has, and this is, I'm going to quote from this part, and they're saying, what we need to decide here is outside the usual course of business. And they answered the question like this: usual does not mean if you do it, it is within your usual course of business. We agree that usual, in accordance with its common usage, simply means that an activity is performed by an enterprise on a regular or continuous basis. And then they continue on. If the activity is not performed on a regular or continuous basis, then the employer has satisfied prong B because the activity is outside the usual course of the business of the enterprise. Okay, now that's in the case that is the Supreme Court cited. Does that? I see some heads going like this and some like this.
But that constrains, excuse me, I'm over here. That constrains the range of things that consultants can do. So, I'm a consultant. I work for a company in Menlo Park, but I also, I consult for a company under contract in Menlo Park. But I also consult for companies under contract in St. Louis and also in Boston. However, the company in Menlo Park is funded by venture capitalists who look at my contract and say, this guy, whatever he does for this company, is part of the normal course of activities that the company needs to do in order to make money. Therefore, they look at my CEO and say, why don't you convert this guy to an employee from a consultant, because after all, he fails the B test here. So what do you say to that? And I'm an LLC, okay? It doesn't protect me from this. And now I'm undergoing negotiation with my company because I have to renew my contract and all that kind of thing. So what insight do you have for those of us who are indispensable to the companies that we're contracting with? And so we fail the B test, but you know, in every other sense, in every other sense, we are consultants.
Yeah, let me ask you a question. How long have you been performing services with that company?
I'm going, it was March of 2018.
Okay, so you're on the verge of being a continuous relationship, which is under Borello kind of a death nail. And that's probably what they're looking at when they're saying that, you know, you should really become an employee. But you're really getting into something that's outside the law. I mean, it's, you know, we could talk about more details and say, well, yeah, there's an argument for being outside of their normal course of business. But if they want to make you an employee and they don't want you as an independent contractor, I mean, they've got the economic leverage. So, you know, that's really what you're dealing with, I'm afraid.
So, I have a question.
Well, yeah, I mean, you can argue with a company that's got all the money on facts, but they probably don't care. But I do represent businesses too, so yeah.
I'm a little new to some of the legalese here, and so I'm understandably confused. But pursuing your translation example,
Right.
I understand the point of the company being a matchmaker. You address the agency, but I'd like to understand what it means for freelance translators and how they fit in. And also, when it comes to the contract, the translator is not contracted by the client company. So in terms of all the contracts, there's a contract to the agency and a contract from the agency to the translator. So I don't understand how the translator is just a matchmaker, is just match-made to the
You mean
client
the company in the business. Well, okay, let's look at the interpreter, translator. You know what, different things, but same for our purposes here.
And Chris, we should go on. We have, you know, a lot more slides to go through.
Yeah, okay.
Should we go on to the next slide?
But this seems rather fundamental, at least to me.
Yeah, very, very quickly. What happens legally is the matchmaker's actually the agent for the school or whatever, and the contract they sign is certainly economically benefiting the contract in the middle, but the real benefit goes to the school or the agency contracting. And my experience is, I've never come across an interpreter who didn't want to be an independent contractor, so I mean, I have no problem with that aspect of it. So yeah, let's
Can I
move
sneak one
on.
in? On B seems.
Okay, so we've gone on to the next slide, which goes into more detail about A.
Yeah, here, this is kind of a wrap-up. I mean, it's, you know, I'm an independent contractor consultant, now what do I do? And this is kind of a summary of what I think you could do to isolate yourself from problems with AB 5, as I read it now and before the courts have gotten to it. But I think it's important for you to take a look at that. You've got to have a written contract. It's got to make sure that it doesn't have control issues, and that's a word of art. And I could talk for an hour on what's control and what's not control. So it's not as simple as it sounds. But if you feel like a word is, if used by the other party to the contract, and it's like, oh geez, I've got to do it because that's what they said, then that's a control issue. Okay, so you use your gut to feel through that one, and you'll probably be pretty accurate. The next one, the perception. Facts, when I go to a hearing, the facts are what the witness perceived. Think about that. That's what you're dealing with, is the semantics to find the word that fits the perception you want to create. It's theater. That's what it is, and that's what you need to work with. I know for engineers, that's not a black and white concept, so it's not quite wrong. But it's not. But that is very, very important to get the perception of actual and factual lack of control. Think about that. Then for B, again, written contract. Yeah, be sure the written contract and facts and services performed that show the services are outside the usual course. Now, if you think about what I read you that the Connecticut court said, you can make that pretty clear. You can make that distinction. If it's not the company's continuous business, then you are outside of the normal course of business.
Relate this to an expert witness for a law firm. Okay? We are in the course of the law firm's business. We're an expert witness, right? Wrong?
No.
Tell me what?
Nope. It's being an expert witness is probably the easiest way to get out of this. Because the law firms do not have experts. They
Yes.
hire you as an expert, okay? It's outside of their normal course of business. They need the expert, but they don't have experts in-house that they can actually use to testify.
If you're an expert witness and
End of story.
and the law firm had control of what you said, it would be your last job ever. Okay, so anyway, B, I think we've been over that enough, I hope. C, this is kind of a summary, but this is important. The independently chosen burdens and benefits. Be firm in your belief, attitude, facts, and terms of your written contract that you at some time prior to the creation of your current client relationship independently chosen the burdens and benefits of self-employment. And think in terms of self-employment. That'll satisfy the concept of business without admitting you're in business. And I don't want you to admit that you're in business because then it brings you under the business-to-business exception, which is a death trap. So anyway, it's so full of
It's a semantics thing.
ambiguity. It's terrible. So anyway, that
And also to underscore what Chris has been saying, this is a law that has not been tested, so all these things are still really, really squishy. So, we just got to go with what the words are and...
Okay, so Chris, a fundamental question is this. Does this apply only to independent contractors or sole proprietors? What if you're already incorporated as an S Corp or even, God forbid, a C Corp? And it's the C Corp that's contracting with the company and you're an employee of your own company. Does that protect you or does that kill you?
Well, how long do you have? It does more protection. It does more good than bad. Let me put it that way. Okay, I mean, by and large, we didn't spend much time on C, but C, the independent business aspect is
Pretty clear.
very important.
Yeah.
It's very important.
And then outside the usual course, I mean, one thing that was brought up again and again, but when you're working as a technical consultant, not as an expert witness, then most people tend to think, well, I gotta be in the usual course of business. But here's another thought, and maybe everyone can comment on that. The very fact that you've been hired as a consultant. I mean, taking the law firm analogy.
Yeah, but you were contracted. So
Yeah, the very fact that you've been contracted, as a consultant to provide them some kind of knowledge, expertise, design, whatever, that they don't have in-house. Doesn't that by definition make it outside the usual course of business? Because if it was, they would have already done it.
No, you're absolutely right. And what you said.
Why would they hire you otherwise?
No, they would. They would hire you. Yeah.
But why would they contract you? I'm sorry. Yeah. No, I mean, yeah. I mean, the fact.
No, and I mean, you're right on point. That's exactly the way it should be. Is the fact? I mean, you've got special knowledge. Think of it as special knowledge that they don't have. It's like the electrician. It's just a little bit more squeegee, okay? But it's like the electrician. How many people in that company can go around and check the circuits and see which one is going to cause the fire next?
Yeah, but see, that's a problem. I'll give you a very concrete example. If you're working with a company, you're working on some kind of a design aspect of a product. Could be anything. In my case, it happens to be telecom equipment. Then it's like threading the needle. So basically what I wanted to ask is, as long as for the next 15 years, we just got to keep threading the needle, right? I mean, that's the only way you can be outside the usual course of business, and you got to figure it out for every project, every contract, you know,
But
every company.
But let me go back to the electrician thing, okay? If you're an independent electrician, you've got, I don't know, 50 clients, whatever it is, okay? You satisfy all of those other elements too. But the business you're going back to, say 3 times a year, 4 times a year, they're not in the business of dealing with electricity. They're a dress shop, a grocery store, a law firm. Believe me, lawyers don't know anything about electricity.
No, it sounds very clear when we talk about electricians, but it's not so clear when you're talking about a chip designer, for example, or a software, you know, expert who's helping design the product that the company is going to sell in the marketplace for millions of dollars.
The concept's the same. If you do chips or something, and then you're in an area I don't know, okay, so hopefully I can hit something that's on point. Let me put it this way. If chips require A, B, C, D skills, and you've got X skills, and they come across a problem that A, B, C, D can't take care of, and they say, wow, that's an X problem. We know this guy. Let's give him a call and bring him in here.
So a pretty common case, you've got a microprocessor company. They sell microprocessors, and periodically they do a tape out, and they need more verification engineers, and they don't want to hire, you know, it's periodic. It's like, okay, now we got a crunch, so let's contract out a few verification engineers. After the crunch, we get rid of them. That's a pretty common scenario. Now, they have verification engineers, they just want some and let them go. Does that mean like that model is no more existent? The real business is selling microprocessors. Where does that fall?
Let me read this again. If the activity is not performed on a regular or continuous basis, then the employer has satisfied prong B because the activity is outside the usual course of the business of the enterprise.
Can the activity be that I am providing additional help to do this, that you don't have the time you need? Could that be the activity?
Absolutely.
Oh my God.
Absolutely. You have, yeah.
Oh wow, okay.
If you've got a contract that says, you know, you've got to produce X by next Friday,
Yeah.
and you can only get X by the following Monday, if you bring somebody else in to do that, that is different from what your employees do. I know, I'm being an attorney when I say that. But that's what you gotta do. I mean, you look at it, and then you give it the smell test.
I'd like to ask how you would relate the DIMAX decision on what he's asking. If here's a company that makes ICs, and every time they launch a new one, they need verification experts, but they need them only periodically. In the DIMAX case, it was lettuce harvesters that are only needed.
That was Borello.
Oh, that Borello, I'm sorry. Borello
Proper.
only needed lettuce harvesters, you know, for a month every year, or whatever it was.
Well, it was a short-term project, okay, but Borello, Borello actually hung on the control issue, because what Borello did is, what the farmer did, is bring in these people once a year to pick the right crop, that was right picked, and the implied part of the control was fill these boxes, take the boxes over there, and etc. It's like there's another example here. A cake company, and I forget, I think this was, it wasn't Connecticut, but it was another outside state. But there was a cake company that contracted with cake decorators to decorate cakes. But these cakes had to have the design that the company made. So these guys could take the cakes and go home and do them at midnight if they wanted or whatever, but they had to follow these designs. Now, that was, then they were they should have been an employee because of that control issue.
Today's meeting is about independent consultants primarily. So, this thing is a little bit off subject regarding the independent consultants thing, but one of the things that Silicon Valley has kind of pioneered in, I think, in a bad way in the last 20 years is extensive use of contract employees inside a company. The way it works is that these recruiters send out emails, and they usually find your email on these job sites, and then usually have and then you talk over the phone and you go do an interview at the company and you get hired. The way the arrangement works is that the staffing company, you're technically a staffing company's employee, but in practice you go work at another site, let's say like Intel is a good example. And you work as a contractor there, and it's usually like anywhere from 3 months to maybe 12 months period. And then after that, you're kind of thrown out, and you're not really an employee of that staffing company. The staffing company has usually gets about like 30% or 40% cut of whatever they're getting. So anyway, so what happens to that business model of contract employment, where you essentially work alongside the regular employees at that company? It's not like your skills like super special compared to the other people, though that depends on the situation. What happened to that contract employment business model that companies around here has really pioneered, and with regard to this EB-5?
I'm going to answer you by looking at the medical community, because I worked in that business model for probably, almost 30 years with that exact business model in the medical community, to a lesser degree in Silicon Valley. And I won all those cases. And I won't go into the legal details, but what you're explaining and what really happened in the medical community was the broker, what I call a broker, placed independent contractors into the hospital. And the question, the EDD came in and audited time and time again. And I won all those cases.
Which side do you want?
I always represent the employer wanting independent contractor. Okay, I always want independent contractor. That's my bias.
And that's a different case.
So the practical aspect of that was the EDD either never caught on, or never realized, or never pursued, and I don't know what, because I never talked to them about it, because it didn't bother me at all, nor my clients. They never brought the hospital into any of these cases, and the hospital should have been the employer. So I won.
Just a short follow-up. So what happens to that whole business model because of AB5? That's why I came here to ask that question.
I'm kidding. Well, under ABC, you can actually, ABC will help you, because you can distinguish, as the broker is outside of the normal business of the, I'm going to say the medical person, but, some kind of other same thing. Then it's going to become how is he treated, he or she treated in the hospital, or in whatever the atmosphere is there. So the burden should really shift to the outside contracting company.
To follow up with the gentleman's previous question, assuming that your clauses A, B, and C can all be satisfied, I'm wondering whether or not it really makes a difference if you're paid on a 1099 basis directly by the guys that you're working for, versus being paid on a W-2 basis by a third party that lined up the job, is taking a piece of his cut. So which is it? If I'm a W-2 guy, am I then an independent contractor? But if I'm a 1099 guy, I'm not so much an independent contractor or consultant?
If you're a W-2, the biggest department you got to worry about is the EDD, because they want everybody to be an employee. If you're an employee, the EDD just says, thank you, and goes on their way. They've got their money.
But in the good old days, late 90s to the tech boom in the early 2000s, what we practiced was incorporating as an S-corp for fear that if we worked for a given client much longer than 2 years, which is a standard practice now, then the EDD would catch on and nail you and say, hey, you're really an employee.
I know too many people to say what I'm going to say, so I'm not going to say it. But they miss stuff, I guess is the easiest way to put it. Like I did say, in the medical community, they never did bring the right party before the court.
It would be tough to do that in the contracting environment in Silicon Valley because some of these contracting agents are out of state, out of country, they're in India,
The
all over
EDD
the
goes out of
place.
state. They go out of state.
Okay.